Never, never, never give up. People that never give you, you don't leave.
I went back to the islands. I was wondering if the conflict attorney for Jordan Taylor and Miss.
Yes, that's me. I would like to speak with her.
Okay, I'll go get her. Also, Miss Shaquilla Hill, supposed to have a private attorney.
Hey there. Hi. Yes, this is me. Here I am.
Okay, great. I'm going to go get those two ladies and I'll be right back.
Great.
Okay. Mr. Real, if you don't mind, would you please put your phone number in the chat for me and so I can have it?
Phone number in the check? What do you mean?
In the chat, so I can have Miss Hill call you so you
I have
can speak.
no idea how to do that.
Or did you? I just wondering if you wanted to speak with her.
Yeah, I sure would, but I don't know how to do whatever you're asking me to do.
Okay. Do you mind just giving me your number?
Sure. 404-229-2519.
Okay.
That's my private cell. By the way, just take down one other number.
Okay, go ahead.
1-800. I'm too sexy for my shirt.
That is sort of like a long distance number, so I may not be able to use that number.
All right.
So I just use the 404.
Perfect. Absolutely.
Okay.
Perfect.
All right, Mr. Samuel Real, I will give you a call.
Thank you.
You're welcome.
Good morning, everyone. Hope everyone's doing well today.
Good morning, Your Honor.
Are we ready to begin with anyone? I see that courtroom 2 is just coming in.
We got add on to Mr. Golston.
Okay, that's I have that someone needs to speak with Mr. Goldston. Is that correct? Whose case is this?
It's my case, Your Honor. Good morning.
Good morning, Ms. McLeod. You need to speak with him prior to moving forward.
I do, Your Honor.
Okay. So can we put Ms. McLeod into a breakout room with 7 South, please? And I guess that we will wait until either courtroom 2 or the South Annex is ready to begin.
Your Honor?
Yes.
May I make an inquiry? Max Shard on behalf of Michael Kirkland.
Good morning, Mr. Shard.
Good morning, Judge. My client, Mr. Kirkland, is housed at the Atlanta City Jail. And I'm just wondering if he is on for today. I mean, on the Zoom for today. If not, I can go talk to him and convey the offers before another court date. But I was just wondering if he's available before I kind of just waited my turn.
Okay, thank you. Ms. Lewis, do we know whether or not
he's on the counter?
I know he's on the calendar, but are we going to be able to patch into the Atlanta City Jail?
That's a good question. I have no clue. That will be up to the jail if they gave that information to them to have them to Zoom in. So I have to have somebody at the jail if they're aware, because they don't want to pull in the inmates.
Okay. Would it, and I don't know what the offer is on this matter, whether it's additional jail time. I would hate to keep him in jail any longer than necessary, but if you want, if he's going to get additional jail time and you want time to talk with him, we can always place him on the next available calendar.
He's being held on some other charges, Your Honor.
Okay.
So if we could reset it for a week or whatever is convenient for everyone, and then I can go talk to him about
But
the
he was
situation.
reset already. He was reset already. We put the other case on the add-on calendar because we thought we was going to address both of his cases. because he's on both the add-on and the regular calendar. So,
Well, if he's been held on other charges and council needs to speak with him, I would prefer to put the cases on for next Tuesday, the 6th, so that we can move forward with those at that time.
it will be an add-on calendar again, because.
That's fine. It's my calendar, so I don't mind having an add-on for it.
Okay,
Okay, is that good with you, council?
That sounds great, Your Honor. Thank you.
Okay, so
that was position, Kirkland, Michael Kirkland, that was position 6 on the regular calendar and, on the add-on calendar too.
and what position was it on the regular calendar?
26.
26. Okay.
And then do we need to notify the jail in advance to make proper arrangements, or should we do a plain abstention? Because I think we're gonna be in square one if we don't.
Good morning.
He is,
morning.
oh, I'm sorry.
That's fine. Good morning, Mr. Walker. Yes, let's make sure that we notify the jail so that we don't have the same issue next Tuesday. Okay.
Was that a directive to me or Ms. Lewis?
It's directed to court staff, Mr.
Oh,
Walker.
okay. I was glad to assist in that.
I wasn't aware that you normally do that.
I don't, but I'll try to, facilitate anyway.
You'll try to assist in any way possible. I understand. All right, so we'll reset position 26, and it's also position 3 on the add-on calendar to next Tuesday.
Okay.
Okay. And
Thank you, Your Honor.
You're welcome. Anything further, counsel?
No, that's it. Thank you.
Okay. Have a good day.
Take care.
Okay. Courtroom 2 seems to be ready. Is that right?
Yeah, I'm just trying to get everything set.
Okay. If you need a minute, you just let me know. I mean,
No, we can go forward, Your Honor. I have position 1, Mr. Kerry Adams. He's also position 1 on the add-on.
okay. And let's see, Mr. Finley, is this your case?
No, that's mine, Your Honor. Thank you.
Oh, good morning, Mr. McLean.
Good morning.
This is going to be an arraignment and a bond hearing.
Correct.
All right. Good morning, Mr. Adams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, Mr. Adams. You can put your hand down. You have been charged in position number 1 on the regular calendar, case number 19 CR 009645Y with simple battery, family violence. And you've been charged on the add-on calendar in case number 22 CR 005618Y with battery, family violence, cruelty to children in the 3rd degree, hindering persons making an emergency telephone call, and cruelty to children in the 3rd degree. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead to these charges, Mr. Adams? Guilty or not guilty? You're mute, courtroom 2.
Not guilty, Your Honor.
Okay, thank you, Mr. Adams. We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Since this is a bond hearing, who do we have for pretrial this morning? Ms. Jackson, good morning. How are you today?
Great, how are you?
Good. Do we have Mr. Adams's history?
Yes, the defendant has 17 cycles. The defendant's last arrest was August the 21st, 2022 with the City of Atlanta Police Department for driving while license suspended or revoked, and there was no disposition for that arrest. The defendant does have prior felony convictions. So one in 2018 for fraud, one in 2007 for possession of cocaine with the intent to distribute, and possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon. One in 2005 for possession of controlled substance. And the defendant received first offender treatment in 1998 for possession of controlled substance. That case was sealed on February the 18th, 2018. Nothing in addition, Your Honor.
Okay. What's the current bond?
It's my understanding that's a $3,500 surety bond on position one. Just bear with me. I'm filling in for ASG King, so I'm just trying to piece everything together at the last minute. On
You're
the
fine,
first
Mr.
case,
Walker.
it's a $3,500 bond, and on his second case, it looks like it is my math is not the best, a $5,000 surety bond in total. On the first case, the victim's name is Octavia Stevens. It looks like there was some type of verbal altercation back in November of 2019. Ms. Stevens was on the phone. The defendant told the victim, "I will kill you and whoever you're on the phone with," and then he proceeded to punch her in the back of her head. That is the basis of the first case. In that case, there was a order of bond to have no further contact with the victim, Octavia Stevens. And I wanted to note that for the court because Octavia Stevens is actually the individual who called 911 in the second case, where the victim's name is Curiana Stevens, and I believe that's his daughter. I could have that wrong, but I believe it was a physical altercation that he had with his daughter in the second case. So we have an individual with two open multiple offenses or battery, family violence. I would just ask that both bonds remain the same. He's already violated the no contact order with Ms. Stevens because she was present on the scene in the subsequent case.
Thank you. Ms. McLean?
I'm sorry,
Well,
Judge. I'm sorry,
Mr.
Judge, not to interrupt you, but the bond amount on the first charge is $4,500, not 35.
Okay.
I'm sorry, that was a bench warrant on the first charge and the second charge. He bench warrant on the first case and the other one was just a $4,500 set good bond by Judge Law.
Well, thank you for that additional information. And to further my argument, due to the bench warrants, obviously we'll be objecting to any modification, but I digress.
Okay, thank you. Mr. McLean?
Your Honor, he denies both charges and maintains his innocence and is looking forward to the trial. He asks the court to consider a signature bond or a substantial lowering of the current bond so he can get out and prepare. He works for STS doing flag control on road construction, highway construction, the folks that set up the flags and have the employees go back and forth with the slow and the stop and the whatnot. His housing is with his cousin, who happens to be his employer, and that is Gregory Thomas. So I've been trying to reach Mr. Thomas, but apparently he's already gone to work. But the person on the lease of the address, he has. So what I'm saying is he's got stable housing. His cousin believes in him, so he's providing a place for him to live, and he's providing him the job, and the job is going well.
All right, well, given that there was a bench warrant on the first case and that he violated the terms of that warrant with the same victim, I believe that the bonds are reasonable, and I'm not gonna modify them at this time. Good luck to you, Mr. Adams.
We're ready to add on to Mr. Goldston.
And we're ready on this, Ms. McLeod.
Yes, Your Honor.
What are we doing with Mr. Goldston this morning?
He's going to be taking a plea, Your Honor.
Okay. Good morning,
It's
Mr.
a
Goldston.
negotiated plea.
Okay, very good. Good morning, Mr. Goldston. I'm Judge Eric Morrow. This is the state court expedited accusation. This is the state court all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Mr. Walker?
Yes, Your Honor, to the one count of battery, the state's recommendation is 12 months to serve, 365 days, credit for time served, 365 days.
Ms. McLeod?
Yes, Your Honor, that is our understanding of the terms of the plea.
Mr. Goldston, it's my understanding that in case 22 CR 005701C, you wish to plead guilty to battery, is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Good luck to you, Mr. Goldston.
Thank you, Your Honor.
All right, next we got position number 33, Mr. Jai.
And this is going to be a negotiated plea?
That was number 33. That's correct. That is a negotiated plea.
Okay, very good. Good morning, Mr. Jai. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. You agree to have your case heard by video? Did you hear me, Mr. Jai?
I heard.
Do you agree to have your case heard by video? That's a yes or a no question.
Yes.
Can you raise your right hand for me? Did you hear my question?
Yes, I say yes.
Okay, well, is your right hand raised? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Mr. Segura, good morning.
Good morning, Your Honor.
You can proceed.
In this case, the state's offer is 12 months to serve 32 days, credit for time served 16 days, and the balance to be suspended. Thank you.
Mr. McClain?
Your Honor, the defendant asked the court to accept the negotiated plea.
All right, Mr. Jai, it's my understanding that in case 22 CR 005403B, you wish to plead guilty to simple battery against a police officer or correction officer, is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury, and that by pleading guilty, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I will accept the plea as negotiated. Good luck to you, sir.
Yes, sir.
Who do we have next?
Your Honor, we have Mr. Antonio Dunn.
Position 13, Judge.
Thank you. It's going to be an arraignment and a bond hearing, is that correct?
Good morning, Judge. And yes, that's correct.
Good morning, Mr. Finley. Good morning, Mr. Dunn. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down, Mr. Dunn. Thank you. You have been charged in case 21 CR 002388G with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to this charge, Mr. Dunn? Guilty or not guilty?
Not guilty.
You will record your not guilty plea, and your case will be returned to the division judge, and you'll get notification of your next hearing date. Let's see, does he have a history?
A moment, Your Honor, I'm sorry, the system is moving just a little slow.
Okay,
The defendant's last arrest was May the 17th, 2021 in Sandy Springs, Georgia for battery, family violence. The defendant only has 2 cycles, and there are no convictions listed in the GCIC gun.
okay, thank you. What's the current bond?
It's a $10,000 surety bond, Judge.
Okay, go ahead, Mr. Finley.
I'm sorry, Your Honor. I didn't realize I was on mute with my camera turned off. I was trying to say in 22 CP 206083, that was a case of false imprisonment and battery family violence. I believe that's what pretrial mentioned. It was DWAP, but I did want to note for the court that it was the same victim. It is a $10,000 surety bond. I will let Attorney Finley go and I'll respond.
Okay. Mr. Finley?
Yes, Judge. I am asking for a bond modification on behalf of Mr. Dunn. As previously stated, as it stands today, he has a $10,000 surety bond, and as was just pointed out, he did have a felony case that was holding him. But I spoke with the PD that was representing him on that case, and he did say that case was no longer being pursued. So this case is now what is holding him. And as of today, Judge, he has now been incarcerated for 218 days. And despite this being a time served plea, that would lead to him being free for the first time in 218 days, he decided to plead not guilty and plans to prove his innocence and fight this charge, Judge. He does have community ties. He is from Atlanta. All of his immediate family that is extremely close with lives in Atlanta. He's also not a threat to the witness, as she is an ex-girlfriend and he has had no communication with her for a long time, and clearly will not have any communication with her, Judge. He has not made any money over the last 218 days and does not have any family that is capable of helping him. So that is why, Judge, I am asking for a $1,500 surety bond for Mr. Dunn, so he can fight this charge from the outside.
Yes, Your Honor, and as PD Finley pointed out, he has served 215 days, but that is in large part because of the felony case he was being held on with the same victim. I understand it was DWAP, but that was more so because of the felony matter. But in this case, with the same victim, her name is Yesenia Naranjo. I'm not sure if I'm pronouncing that correctly. Law enforcement responded to 6885 Peachtree Dunwoody Road, apartment 205, and speaking with the victim, she advised that the defendant had became inebriated. A verbal altercation ensued. He pushed her to the ground and stomped her on her face. The defendant tried to assert that he was defending himself, but the defendant had no visible marks. The victim did have swelling to her face. At that time, the defendant was arrested and charged with battery family violence. We were asked that the bond remain the same, Your Honor. Okay,
Without having any prior convictions for battery or battery family violence, I'm inclined to reduce the bond to a $1,500 surety bond with the same conditions as was on the previous bond, Mr. Finley. So do you have those conditions?
If you could, I can. I just want to make sure I have them down correctly.
Okay, I don't have them, so.
Okay,
that's
yeah,
why.
I have. Yeah, I have them, Judge.
Okay, all right, so make sure that the same conditions and it's a $1,500 surety bond. All right, good luck to you, Mr. Dunn.
Good morning, Your Honor. The sub-annex is next with position 19, Ms. Shaquila Hill.
Okay, good morning, Officer Mills.
Good morning, sir. Good morning.
And good morning, counsel. What are we doing with Ms. Hill this morning?
Well, that's a very good question, Judge, because at the end of the day here, I only just last night, well, actually this morning, early this morning, had a few-minute conversation with the solicitor on the case. The solicitor believes that Ms. Hill should do as much as a year in jail and as heavy a fine as can be on the case. I don't think he currently, I think that there's also a felony case that she has pending in Fulton County. Bottom line is this, that I think that when the solicitor sees, like the district attorney is going to see, that she has a long and a very serious history of some mental illness ever since she was raped as a child, and has that happening, she'll at the end of the day, I think he will agree that she needs to be in some kind of a mental health facility, which we've picked and got arranged. He doesn't have any of that information yet. He will have it. So bottom line, I don't think much can be done today relative to the current case. I know that the sister is who is the victim in the misdemeanor case is actually on. She doesn't want to prosecute this case, but I guess that'll be determined when I get in touch with the solicitor at greater length.
Okay, so it sounds like you would like to have a continuance on this matter. How long of a continuance do you think you'll need to speak with the solicitor?
I hope that should be within about a week. I had a 2-minute conversation with him this morning. That's not enough time for him to analyze everything and for me to present it. So it's hard to say exactly.
Your Honor, just FYI, she's not being held on this case. She's being held on her felony matter. I'm not sure if the defendant is arraigned, but if she's not arraigned, we're just going to request that she's arraigned and reset further notice. I really don't want to get into the accusations of the case, but if it involves a firearm, and again, she's not being held on this case. So,
okay, even if she's not being held on the case and she has an issue with mental illness, I would think that would be something that the state might want to
I
consider.
agree, but if it's to that point, I would suggest a competency evaluation. I mean, that's what we typically do if it's that significant.
And I'm happy to give you and Mr. L an opportunity to speak on that. And if that's what you both agree on, then I'm happy to order a competency evaluation.
That would be the state's request, respectfully.
Okay, and that's fine. So I want to give you all the opportunity to at least have time to speak on the matter. Can we reset this until next Tuesday?
Yes.
Does anybody have an objection to that?
None.
Okay, so we'll reset till next Tuesday, and you all, when you come back, we'll move forward at that time. Okay.
Fine.
Is that everybody's in agreement?
Yes, Judge. I have another case also on the calendar today, I might add, that is on a Shannon Muhammad, but I just thought I'd let the court know that.
And do we have Ms. Muhammad at the South Annex?
No, she's in the medical unit, Your Honor.
Okay. All right. So
And
we'll have to give her some
medication
medical
for the officer to get there.
Okay.
But now we have position number 18, Mr. Joshua Hensley.
And this is going to be an arraignment and a bond hearing, is that correct?
That's correct, Judge.
Good morning. And where's Joshua? In courtroom 2?
That is correct.
Okay, good morning, Mr. Hensley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, thank you. Mr. Hensley, you've been charged in case 17 CR 015996Y with battery. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to this charge, Mr. Hensley? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, is there a history
Defendant has 22 cycles. The defendant's last arrest was August the 17th, 2022 in Clayton County for driving without a valid license. There is no disposition for that. Prior to that, the defendant was arrested on March the 3rd, 2022 in Clayton County for driving without a valid license. And then I do see where the defendant received a conviction, felony conviction in Fulton County on March the 2nd, 2022 for aggravated assault, probation, 2 years and 8 months, confinement 4 months.
And Judge, this is an FTA case to let you know.
Okay, so this is a 2015 matter. If he pled guilty to aggravated assault back in this year, why wasn't this charge handled at that time? Do we know? I guess not. All right, so Mr. Segura?
Yeah, this case occurred back in June the 19th, 2015 at the incident location of 1763 Carter Circle, East Point. In this case, the police met the victim, Ms. Deborah Morris, Deborah D-E-B-O-R-A-H, Morris, common spelling. And she stated that she's the property owner of that incident location, and she came to the incident location to collect rent from the defendant and a different party. At the time, she was advised that there was a tile that needed to be repaired, and afterwards, Ms. Morris expected the pile, and after she collected the rent, the defendant became upset. At that point, the defendant began to yell at Ms. Morris. Alongside, she said that he was mostly saying he did not mind paying rent, and that she, as a landlord, was not making repairs. At that point, she stated that it would be best for the defendant to find another place to live, at which point the defendant became even more irate. Then he grabbed her as she was walking out the front door and told her to get the money XXXX out of his house, then began to push her out. At that point, Ms. Morris fell backwards onto 2 chairs, which ended up bruising and cutting her hands, arms, and knees. And at this point, there was another tenant who warned the defendant not to put his hands on Ms. Morris, and also her co-worker who was with Ms. Morris, Ms. Felicia Thomas, common spelling, also came out and witnessed these acts. At that point, Ms. Thomas called the police and the defendant was arrested. Based on the history, aside from that recent aggravated assault conviction, the defendant also has a 2021 arrest for simple battery felony bonus, 2019 simple battery, and 2009 simple battery conviction. As far as his history, as for his amount, he initially had a $2,000 signature bond, but he ended up doing an FTAing on his jury trial on December the 5th, 2019, which was by Judge Edie, in which he had a bench warrant. And at that point, he also had an FTA for his jury trial back on April the 12th, 2022, in which he did the FTA, and thus he was given a $3,000 cash bond. So because of his FTAs to his jury trials, we're asking the court to retain the $3,000 cash bond amount. Thank you.
Okay, so it appears, Mr. Finley, that he FTA'd on a jury trial before Judge Edie, and Judge Edie issued a $3,000 cash bond in this matter. And you know how I feel about these types of cases, that given that the division judge gave him this bond, you're going to have to go back to Judge Edie if you want it modified.
Understood.
All right. Good luck to you, sir. Who do we have next?
Add-on 4, Jordan Taylor, conflict attorney, Ms. McLeod.
What are we doing with Ms. Taylor, Ms. McLeod?
We're going to take a plea, Your Honor.
Okay. Good morning, Ms. Taylor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Ms. Taylor. Good morning, Ms. Johnson.
Good morning, Your Honor. It's my understanding that this will be a negotiated plea. The state did offer the null pros on the cruelty to the children in 3rd degree, 12 months to serve 46 days, credit for time served 23 days, balance probated. a family violence intervention program, no further violent contact, and no alcohol, drugs, or weapons.
Ms. McLeod?
That is my understanding of the terms of the plea, Your Honor.
Okay. Ms. Taylor, it's my understanding that in case 22 CR 001210E, you wish to plead guilty to simple battery family violence. Is that correct?
Yes.
She wishes to plead no contest if she can, Your Honor.
Is there an objection to a no contest plea, Ms. Johnson?
Yes, Your Honor, there's an objection.
Okay. I need to know, so this is not a negotiated plea if you all are not.
It is, Your Honor, if she will plead guilty.
Okay.
We weren't sure she would be able to
Okay, all right.
plead
So-
no contest. If she could, then we would want that, but if she can't, then she'll plead guilty.
Okay, so, and what is the state's objection to the no contest plea?
Due to the type of charge, we typically object to no contest pleas on certain types of charges, and that would fall into this category.
Does she have any other violence charges in her history?
I would defer to pretrial, Ms. Johnson.
I have
a-
please. Go ahead. I'm sorry for interrupting. Go ahead, counsel.
No, Your Honor, I'm sorry. I was just gonna repeat what I have for her history, but you'll probably have an up-to-date GCIC.
I'm sorry. Can I have that position? I heard Ms. Taylor, but I didn't hear the position.
It's on the add-on calendar number 4, Ms. Jackson.
I did not receive the add-on calendar, Your Honor. So may I
Okay.
please have her full name and her booking number, please?
Let me just see if Ms. Johnson has her history. Ms. Johnson, do you have the history?
Yes, Your Honor. I have a theft by shoplifting from 2018 in Loganville and a probation violation in 2018.
So she only has one, to your knowledge, she only has one guilty plea on her record, and that doesn't involve violence.
To my understanding, but also, Your Honor, the state's argument, she does have previous incidents with her mom. Now, I do know the police did go to the residence, however, no further police reports were filed, but I do have concerns in this case, Your Honor.
Okay, well, if she doesn't have a history of any convictions for violence, I am going to allow her to use her no-load plea for this simple battery. Okay?
Thank you, Your Honor.
Ms. Taylor, it's my understanding that in case 22 CR 001210E, you wish to plead no load to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading no load to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead no load?
No, sir.
Okay, I'll accept the no-load plea as negotiated, Ms. Taylor. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. But you'll have to be on probation for the entire time, okay?
Yes, sir.
All right, good luck to you, Ms. Taylor.
Thank you, Your Honor.
Excuse me, can you go over the conditions of the plea again for probation? Is it no further violent contact, and you didn't name the person?
Yes,
No
it's no
further
further
violent
violent contact with her mother, Miss Dana Miller. She's also on the line right now. It's no alcohol, drugs, or weapons. A family violence intervention program. And then for the time, it's 12 months to serve, 46 days, 23 days credit for time served, balance probated.
Thank you for clarifying that. Appreciate that.
Yes, ma'am.
All right, who do we have next?
Can we do position number 2?
I have that position 2 was released.
No, position 2 is right here, Mr. Ash. AKA.
Judge, that was a mistake. That one is actually a negotiated plea. I did correct that with the Officer Norris today.
Okay. Good morning, Mr. Ash. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Okay, you can put your hand down. Thank you, Mr. Ash.
Thank you, sir.
You're welcome. Mr. Walker?
Yes, Your Honor, the state's recommendation to the one count of criminal trespass is 12 months to serve, 365, credit for time served of 365.
Mr. Finley?
Yes, Judge, and that is our understanding of the offer, of which we do agree and stipulate the factual basis, venue, and ID.
Mr. Ash, it's my understanding that in case 21 CR 002895A, you wish to plead guilty to criminal trespass, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, I'm not, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir, Judge.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty, you're giving up your right to a trial by jury?
Yes, I do, Your Honor.
Has anybody forced you or coerced you to plead guilty?
No, they haven't, Your Honor.
Okay, I'll accept the guilty plea as negotiated, Mr. Ash. Good luck to you, sir.
Thank you, sir.
Who do we have next?
Your Honor, we have position number 20, Mr. Hines, Marlon Hines.
Okay, this is a non-negotiated plea, is that correct?
Your Honor, he was asking me to get hold of the state and ask if they could change the terms so it could be an actual negotiated plea, and I put that in the chat to Mr. Walker.
Mr. Walker?
I haven't had the opportunity to review the chat. I'm doing several things, but if you just give me 1 second, I will take a look at the request. I mean, or you could just state it on the record. And
Right, why don't you just do that, Mr. McLean? What's the offer, Mr. Walker?
It's not my case, so I'll let.
Okay, all right.
It was simply stay out of Walmart's, which is absolutely, he's committed to doing that. He was wondering if the state could agree to delete the anti-theft class because he's so homeless and so broke, he thinks he would fail at finding and paying for such a class. And on the 60 hours community service, he was saying, gee, that's a lot. I need to spend all my time job hunting because I'm so broke and so homeless.
How much time has he served?
Let's see, how many days has he been in there? That's number 20, isn't it?
It is. The sheet says 20 days. I mean, 7 days. 7 days.
It's got down the calendar is showing credit for time served 13 days.
And jail for 13 days as of today.
We will drop the theft class and we will reduce the community service hours to 20. And I mean, as soon as he finishes those 20 hours, the probation can terminate. I don't know if he'll take that.
Let's see, is he hearing us, Mr. Hines? Did you hear Mr. Walker's idea? That it could be a negotiated plea if it has no anti-theft class, and instead of 60 community service hours, it would be 20. Is that acceptable to you?
You're mute, courtroom 2.
Will be terminated right after the 20 hours, right? Start from the beginning again.
Yes.
Also, Mr. Hines, that will be the probation will be over with as soon as you prove that you have done the 20 hours of community service. Is that what you wanted them to agree to? Is that what you agreed to? I can't hear anything.
Mr. Hines, can you hear counsel?
Say it again. Yes, I will agree to that. Yes, sir.
Okay, then that's a negotiated plea.
And of course, there's a stay away, but I'm sure you already knew that, Mr. McLean.
Right, he did say he was absolutely committed to staying away from all Walmarts.
All right. Anything further before we take the plea?
Nothing.
Can I get confirmation it will be 20 hours of community service terminated upon the completion of 20 hours?
Right, that's going to be in writing in the sentence, Mr. Hines.
Thank you.
So that'll be the confirmation.
Confirmation.
Okay, so Mr. Hines, it's my understanding that in case 22 CR 005537J, I'm sorry, did I already swear you in, Mr. Hines?
I'm sorry.
Can you raise your right hand for me?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Is that a yes, sir?
Yes, sir. Yes, sir. Sorry.
Okay, you can put your hand down, Mr. Hines. It's my understanding that in case 22 CR 005537J, you wish to plead guilty to theft by shoplifting, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Hines. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And as soon as you complete the 20 hours of community service, the probation will terminate, okay?
Yes, sir.
All right, good luck to you, Mr. Hines.
Thank you. You good? Next, we have position number 31, Mr. Adam Morris.
This is going to be a negotiated plea?
I believe that is correct, yes.
Okay. Good morning, Mr. Morris. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. To agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Segura?
In this case, the state's recommendation is 12 months to serve 30 days, credit for time served 15 days, banned probated, and anti-theft class, a stay away from 9165 Roosevelt Highway, Palmetto, and no further contact with Norman Herrick. Norman, common spelling, Herrick, spelled Herrick. Thank you.
Mr. McLean?
He asked the court to accept the negotiated plea, Your Honor.
All right, Mr. Morris, it's my understanding that in case 21 CR 001033B, you wish to plead guilty to theft by taking, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Good luck to you, Mr. Morris.
Thanks, sir. Your Honor, can we go to position number 11? I believe there's a private attorney on for Mr. Cronin.
Okay.
Good morning, Judge Thomas Flugum. I'm actually here on behalf of the bonding company, a second chance bail bonds. We are here and filed a motion for relief on the bond. I don't know that my client realized that Mr. Cronin was incarcerated at the time, but I do believe that we're entitled to separate relief based on failure of the state to comply with the 10-day notice provision. I'm just here asking for Your Honor to sign an order granting relief on Mr. Cronin's bond to a second chance bail bonds. I believe the total amount requested was $3,500 was the bond on the case.
All right. Mr. Walker?
Well, I thought typically these type of matters are handled on a bond forfeiture calendar, no, or
It's on a bond forfeiture calendar with Judge Morrison.
right. So I would defer to Judge Morrison and that calendar date, respectfully.
Judge, my view is that, we've attached the exhibits to show that really we're entitled to relief. I spoke with your assistant when she set the case, and I told her I was here on behalf of the bonding company. We did file the motion. I know we filed an amended motion recently, but I believe the motion's been pending for almost a month. And this was the first notice that we've been able to get anybody to get back with us about a date. And so I've been having trouble getting these set, especially in cases where it seems like the defendant is here. I mean, we're entitled to come off the bond once he's surrendered to the court. So, I'm just formally asking that we be released on this bond. I don't think really there's any, the state's position generally is that they can test bond. So if we're asking to come off of it, I think we're on the same team here.
Like I said, I typically don't participate in bond forfeiture calendars if it's already scheduled for a date in front of Judge Morrison. I would defer to Judge Morrison in the courtroom, and
What date is this going to be heard by Judge
It's
Morrison?
on a November the 2nd bond forfeiture calendar, Judge, and the orders and stuff to go through Judge Morrison. It'll be up to her case manager if they want to schedule an early hearing. He will have to go through her case manager for her court, but it's already on a bond forfeiture calendar for November the 2nd.
all right, and I'm not trying to step on, I'm not disagreeing with counsel, but I'm not trying to step on anyone's toes. I realize it's not something that we typically do on this calendar. So I just ask that the regular procedure is followed. But of course, I digress to you, Judge Morrow.
And Judge, we did get notice. I explained to the court that what we were here for. I've served the state with a copy. And so I would just ask for the ruling that the law requires. It states that that the 10-day provision should be adhered to strictly. I've attached exhibits showing that the 10-day rule was not followed. It doesn't sound like the state has any indication that it was followed in contradiction to our motion. And so really, this sounds like it's just, there's no harm in granting our motion. If we just punt this to November 2nd, my client, who's a small business owner, employs 30 people in the local area, is holding on for another 3 months on a $3,500 bond that we all agree that he's entitled to relief for. And so, Judge, again, the bonding law actually says that if we forfeit the individual or he's turned up in jail, we are granted immediate relief, I believe, without any filing of any motions. And so we went ahead and filed the motion just to let everybody know what we were requesting. It doesn't sound like anybody says that we aren't entitled to relief. And so I just ask that Your Honor sign an order so that we can get off this case and move on to we're one of the biggest bonding companies here in Fulton County. We're not going anywhere, Your Honor. But this is one that we are entitled to relief on. So we're just asking for the order granting that so we can forward it to the bonding administrator.
Judge, he was only on the calendar because he FTA before Judge Morrison. So that's the reason why he's on the calendar.
Thank you, Ms. Lewis. What I normally do in these cases, and I understand your argument, counsel, but this is not a calendar that we handle bond forfeitures on. I suggest that you get in touch with Judge Morrison's staff and see if you can get on an earlier calendar with her, or if she will consider your motion without having to be placed on a calendar. This is the state all-purpose calendar. We do not normally handle bond forfeitures. So. And when there is a division judge who has issued an order, I typically have counsel return to the division judge who issued that order to deal with it. So I suggest that you get in touch with Judge Morrison's staff regarding the matter. Maybe you can get some relief with her.
Judge, I do foresee one small issue. Obviously the entire case was transferred to you guys for SAP. That's why I was reached out to specifically by your scheduling coordinator for that I appear. So, I can go to Judge Morrison, but Judge Morrison's staff does not have the case any longer because I believe the 20 CR is the one that was set in front of you today.
With all these cases, the division judge still presides over the case. They just give us these cases so that we can dispose of them if we can. And again, like I said, we don't normally do bond forfeitures. And when somebody does have an issue of this, I have the case returned to the division judge. So I'm going to follow what I typically do in these types of cases and refer you to Judge Morrison for relief.
Okay. Thank you, Your Honor.
All right.
Will this case still be a negotiated plea with the PD?
Judge, if there's a negotiated plea to close the case out, then the bond forfeiture is going to go away and I'm not going to have an opportunity to be heard.
Okay. So there's not a negotiated plea then?
It's not my case. I don't know. But if the state's in a position to close the case out, then I don't understand why we can't be relieved.
I think the mix-up was, Judge, that they put him on account because they did not know he was associated as the surety for the attorney for the surety. And I think the clerk was the clerk was not understanding that he's not representing the client on the counter. He's just representing the bond company. And I think that's what the mix-up was. And that's the reason why he probably was notified, because somebody associated the case with the attorney on it. And I think that's what the mix-up come from. but he's in jail for the FTA that he failed to appear before Judge Morrison. This case is on a bond forfeiture counter for Judge Morrison. The orders have been forwarded to Judge Morrison. It's going to be up to her chambers, her clerk, to administrate an early, hearing on it. But like I said, if the PD, if they're going to do the cases, yeah, true, I understand what you're saying, sir. If he takes a plea, yeah, automatically you're supposed to come off. Would that be prior to her Judge Morrison termination when her hearing? You would just have to let the courts know. You just have to file, I guess, another motion to verify the case is closed.
Well, then, Judge, we would object to the plea today, and we would ask that this be set in front of Judge Morrison, because if the court's going to close out his case, it entitles us to relief. And so what we're saying is that we're going to let him close out his case, but we're not going to keep us on the hook for a bond that everybody agrees that we don't have to pay. And so we, for one, would object to a plea. If the case is going to be closed out, it needs to be, if we're required to go in front of Judge Morrison to get relief, then our position is that the defendant needs to be set in front of Judge Morrison to take the plea so that we may be all heard at the same time. Because if the court is going to close out the 20 CR 005304-E, that is the case that we're on the hook for, and we would be entitled to relief once the case closes.
Okay,
So it doesn't.
look, I'm not an expert in bond forfeitures, but I think we're mixing a little bit of civil law with criminal law. You have no standing to object to a defendant taking a time served plea. Like, you don't represent him on that matter. It's up to PD Finley and the client if they want to take a plea. It's a negotiated plea. It's time served. So for you to say you to object to someone taking a plea because your company will be on the hook for X amount of dollars, that's a civil matter.
Right,
That's-
but we're
that's
bond
not a criminal
forfeited
matter.
because he
So,
didn't appear.
again, this is a stay all purpose calendar. This is not a bond forfeiture calendar. This sounds like it's something that's civil that needs to be taken up with Judge Morrison. So I would just ask that we proceed with the plea. And as Judge Moore already stated, you could take that up as a separate issue with Judge Morrison.
But Judge, if the case closes today, there won't be a bond forfeiture calendar.
Right,
Because
and
the case is going to be closed.
that's a civil matter, not a criminal matter.
Yes, it will still be a bond forfeiture counter. Judge Morrison, do not delete her bond forfeiture counter, so you still can appear on November the 1st and argue at that time to be relieved.
Judge, do you understand our position that the case that we're on the hook to make sure he comes to court on is closing today, but we're going to still be ordered to pay as if he hadn't appeared and closed the case?
I understand your position. I don't know anything about this case. Let me just say that first and foremost. Mr. Finley, I don't know if I have that it's a negotiated plea with regards to Mr. Cronin today. And generally with negotiated pleas, I'm not going to keep somebody in custody. And I'm not even sure what the negotiated plea is at this point, but I'm not going to keep someone in custody simply over a bond forfeiture that can be handled at another time. So if that's the case, then Mr. Finley, what is your pleasure on this?
I mean, obviously, Judge, I met with Mr. Cronin yesterday, and I want him to be free, and I want him to walk out of the Fulton County Jail. It is a time-served, balance suspended offer. And I think, I'm not sure, but I'm assuming what happened with him getting the Zoom link is there was an entry of appearance as if Mr. Flugum, I'm not sure if I'm pronouncing it correctly. It was on his Odyssey, Mr. Cronin. So I think as if that was his lawyer, but it was really the lawyer for the bonding company. But I mean, obviously, this is a negotiated plea, and I want Mr. Cronin to be free. He wants to be free, and I mean, this is.
And it's a negotiated plea, so I think we're mixing civil law with criminal law. I don't specialize in bond forfeitures and things of that nature, but
Judge, the purpose of a bond,
Judge Morrison issue. We have
the purpose of the bond is to ensure that the defendant comes back to court.
A time served plea.
The purpose of the bond is to make sure that the defendant comes back to court, and we sign on as a guarantee by the defendant that he's going to come back to court. He is now in court, and we are going to close the case that he is out on bond on. But the state's position is that even though that the case that's closed, that we posted the bond on to make sure he comes back to court, is being resolved today, that we still have to pay his bonds. That doesn't make any sense. The case is being closed today. Why can't we just all agree if the case closes today, the bond goes away because the case is over? So I don't understand the issue. If the state and the defendant are closing the case, there is no bond left to forfeit, right? Because he's come into court and submitted himself to the authority of the court to close the case. If it's a security deposit to make sure he comes back and does that, I don't understand what we're fighting about.
Well, if I may, what we're fighting about is that my client would have to sit in his tiny room behind a locked door for 23 hours. So
I have no problem him getting out as long as it's seen that we don't have to pay the bond. Right now, we're ordered to pay a $3,500 bond on this guy who's going to close his case out today because he didn't show up last time. And so he's here now. He's going to close out the case today. The bond was posted to get him out in preparation for these charges, and he's closing it out today. So the bond was a security deposit on a case that's closing out today. And so if it's closing today, I don't understand why there's even any bond associated with it going forward. That's not a civil matter. The state argued for bond in the first place. And I think everybody understands it. When the case closes, there is no more need for bond. So if it's closing today, why can't we also get our order signed?
Okay, what is the negotiated plea, Mr. Walker?
Give me 1 second, Your Honor. I have several things open, but it's essentially a time served balance. It's been one second. So 12 months to serve, 92 days. Credit for time served, 46 days. Balance suspended. Stay away and no further contact with the victim. I will have to get you that address and the victim's name, but essentially those are the terms of the plea.
Okay.
The other charges are crossed too?
And then the second charge of simple assault will be no price. Thank you, Ms. Lewis. That is correct.
So what I'm going to do, Mr. Flum, I have not seen any of your filings in this matter. So if Ms. Lewis or someone can get me those, I will take a look at them today to see what's appropriate with them. If I think that it's more appropriate to return them to Judge Morrison, I will do that. If I think it's appropriate to get them signed and be done with it, I will do that. I'm gonna have to take a look at it first. I'm not going to keep Mr. Cronin in custody over this issue. So I'm happy to look at what you have, but I'm gonna have to take it under advisement as I've not been informed of this prior to today's hearing, okay?
And Judge, I'm actually upstairs in Judge Porter's courtroom. I have a courtesy copy with me. If you're in the building, I'm happy to drop it by.
Okay, no, I'm not in the building, but
Okay.
if you can get that, Ms. Lewis, are you in the building today?
Yes, I'm in my office, but the original has been forwarded to Judge Morrison, and it's all on the system, because you know, we do e-filing, so it's paperless. So I will have to.
I can flip an email copy too. I have a scanned copy in my file, Your Honor. What's the best email for me to send it to?
Sent it to the Fulton County, my Fulton County, it's Kenneth.Morrow.
At Fulton County GA.gov.
Yes.
Thank you, Your Honor. I'll get that to you shortly.
All right, very good.
Thank you.
Okay. Mr. Cronin. Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Sure.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Does Mr. Walker, Mr. Finley, you have anything to add to what's been said at the present?
No, but I do have a stay away address. It's 2814 Spring Creek Lane, Sandy Springs, Georgia. No further contact with James Cronin, Cronin.
Okay. Anything further, Mr. Finley?
And nothing further, Judge. That is our understanding of the offer, and we do agree.
All right. Mr. Cronin, it's my understanding that in case 20 CR 005304E, you wish to plead guilty to simple assault family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Cronin. Good luck to you, sir.
All right, thank you very much.
And that's at 27 and 28, Mr. McBride.
Your Honor,
Yes.
Mr. McBride was simply pleading not guilty and he wanted to check. He says, I've already made bond on these. I don't believe the bond on these cases has been taken away. I didn't have time this morning to check and make sure he was correct on that. But he believes that the bond issue is not one that he needs to address because he believes he's out on bond on these, but he's in on something else. So similar to another case we have today, if the bond issue for this is moot, he's simply pleading not guilty and could waive the arraignment.
You're going to file a formal waiver of arraignment, Mr. McLean?
I'll make a note to do that right after court and file that. We have a form for that.
Okay, all right. So there's nothing further that we need with Mr. McBride. Is that correct?
That's correct, as long as this is not holding him in. And that's also true of Mr. Hollis, which is position.
Well, let's just do one at a time. So let me
Sure. Okay.
let me get through with Mr. McBride. Are we done with Mr. McBride for this morning?
Can I ask a question, Your Honor, please, sir?
Yes. Good morning, sir. You have a right to remain silent. Anything you say can be used against you. Mr. McLean, do you need to speak with Mr. McBride? I don't want him to ask a question that might not be in his best interest.
Mr. McBride, you understand why normally what we do is just talk in confidence. So if your question is about what we've talked about, it'd be best if you and I talk.
No, I just wanted to ask the judge about something, please, sir, about Mr. Monroe, because this case was dismissed in January, and they still, I don't know what the system glitch is or nothing, but
okay.
Was dismissed.
That's not really a matter for today.
Okay.
Mr. McLean will speak with you regarding that, okay?
Yes, sir. Yes, sir.
All right. Good luck to you, Mr. McBride.
Okay.
Thank you.
Excuse me, Mr. McLean, he's already been arraigned on position 27. I just need a waiver of arraignment on position 28.
On 28. Okay, very good. Thank you. We'll make a note of that.
And Mr. McLean, what was your other issue?
Oh, Mr. Hollis is also in a situation where he's simply pleading. He's number 22. Mr. Hollis is not guilty, asked for a trial, and his bond is moot. His bond is about as moot as it can get.
Are you going to file a waiver on Mr. Hollis also?
Yes, Your Honor, I can do that. I'll do that.
Okay. All right. Thank you, Mr. McLean. All right. Who do we have next?
Your Honor, you can go to medical.
Okay. Who do we have in medical?
I guess she left. We can go to Mr. Bird.
This was Mr. Hollis, but y'all doing a waiver. All right.
Okay. Thank you.
Okay. That sounds, yeah, that's why I was going to medical. Position number 9, Mr. Bird.
Number 9, Mr. Bird. Okay.
And this is going to be an arraignment in a bond hearing?
Yes, Your Honor.
Good morning, Mr. Bird. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Bird, can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Bird. You've been charged in case 19 CR 0020001Y with battery substantial physical harm. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Mr. Bird? Guilty or not guilty?
Not guilty.
And we'll record the not guilty plea, and the case will be returned to the division judge. And you'll get notification of your next hearing date. This is a 2018 case? Was this a
FTA.
FTA?
It started out with a pretrial release bond. So we would object to any modification and ask that it's sent back to division
What,
to Judge
what
Edie.
what did he miss, Mr. Walker?
Let me pull up an Odyssey. I just had it. 1 second.
Mr. Plea and arraignment.
8/5/2019. That's the latest FTA was 8/5/2019. So he's in on a, well, actually he missed a couple of plea arraignments. He missed 3 plea arraignments. So.
Okay. So, Mr. McLean, I normally return these to the division judge, so I'll do the same with this case.
Right, Your Honor, on the bond matter, he simply was saying, you know, he's been working for the city of Atlanta for 4 months, hanging on to the back of a truck in the solid waste division. And prior to that, he's had a career as a forklift driver and gave me 2 examples of forklift warehouse work that he's done. And he says that his FTAs, he had thought it was over. He didn't realize he was FTA. And I explained to him that, you know, the Fulton County Daily Report is his best way of, if you can't trust your mail, then you got to get with the Daily Report.
Okay, again, I'm going to return this to Judge Edie to address the bond matter. Good luck to you, Mr. Byrd. Who do we have next?
Next, we have Mr. McCoy, Alavius McCoy.
You have a position number, I'm sorry.
I'm gonna get the position number.
Thank you.
Behind. I got you, Mr. Walker.
I was just trying to keep up. It's one of those days.
He's position 29, position 30.
Okay, that's not me.
All right, so it's my understanding that this is going to be a negotiated plea. Is your case, Mr. McLean?
It is, Your Honor. What number is McCoy? He's got 2 positions, correct?
29 and 30.
Those are negotiated pleas.
Okay, very good. Good morning, Mr. McCoy. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you, Mr. McCoy. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, sir. Good morning, Ms. Reed. Is this your case?
Good morning, Your Honor. Yes, it is.
Okay, you can proceed.
Okay. For position number 30, that's 21CR005583Y. The recommended plea is 12 months, served 32 days, commuted for time served 16 days, balance suspended, and a stay away from the incident location. As for position number 29, that's 22CR005376Y. That position, that plea is also 12 months, served 32 days, commuted for time served 16 days, balance suspended, stay away. And that sentence is to run concurrent with the position 30 case, the 22 CR case.
And I wondered, what is the incident location he is to stay away from?
Okay, that's 2174 NELMS, NELMS Drive, Southwest Atlanta.
Okay, that's what I thought. So, Mr. McCoy, you and I discussed staying away from Nelms Avenue, correct?
Yes, sir.
That's very important. Can you do that?
Yes, sir.
Thank you.
Thank you.
Anything further, Mr. McLean?
That's all, Your Honor. He just asked the court to accept his plea
Okay.
on each.
Mr. McCoy, it's my understanding that in case 22CR005376Y, you wish to plead guilty to criminal trespass, and in case 21CR005583Y, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir. Yes, Your Honor.
Okay. Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. McCoy. Good luck to you, sir.
Thank you. Next, we have position number 9, Mr. Bolton. Position number 6. My apologies, Mr. Bolton.
That is also a negotiated plea.
Okay. Good morning, Mr. Bolton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Can you raise your right hand for me, please? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Mr. Walker?
And Your Honor, I would just like to clarify, this offer was made as a global resolution for 2 cases. Is it council's intention to plead out to both cases or just one?
Both cases. Should we call the second case 6A on the calendar? We have the case number.
Yes, the 1 6A and one is 4A and it'll run concurrent. I just wanted to make sure we were on the same page.
Okay, so I don't have anything on my calendar except for a simple battery, family violence, and a theft by taking. If you want to put the case number and the charge on the record for me, Mr. Walker.
Yes, Your Honor. So that second case number is 21 CR 003784A, battery, family violence. And if you hear me say anything incorrect, Mr. McClain, please do correct me.
Okay, so let's start with case 466A.
Okay, so the recommendation would be 12 months to serve 30 days, credit for time served 15 days, balance probated, FVIP, no further contact with the victim, and a stay away. Give me 2 seconds. I will give you the address and the victim's name. But essentially, it will be the same exact sentence for that second case to run concurrent. It's the same exact victim in both cases.
Okay, you have that down, Ms. Lewis?
Yes, I have it.
Okay, thank you.
And just 2 seconds, I will get you the name and the address, Your Honor.
Your Honor, he and I discussed both cases. I did note to him the consequence and the legal distinction and the consequence in the future if there were to ever be a second charge, which he is absolutely committed there will not be, that a battery, family violence is different. The second time is charged as a felony. So he understands the difference between battery, family violence and simple battery, family violence. He asked the court to accept his plea on both these cases.
Okay, and the victim's name is Charmaine Hargett, and that address is 5785 Deerfield Trail, Atlanta, Georgia.
Okay, anything further?
Not from the state, Your Honor.
Mr. McClain?
Nothing, Your Honor.
Mr. Bolton, it's my understanding that in case 22 CR 005466A, you wish to plead guilty to simple battery, family violence, and theft by taking. And in case 21 CR 003784A, you wish to plead guilty to battery, family violence. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Bolton. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire time, okay?
Yes, Your Honor.
All right, good luck to you, Mr. Bolton.
Thank you, Your Honor.
Next, we have position 17, Mr. Joseph Paul.
And Judge, I did speak with Mr. Walker, and I think we were going to reset this case so he has a couple other misdemeanors that we'll take all together, I believe, on Thursday.
What would you like to, Mr. Walker?
I was gonna say, if that's possible, Ms. Lewis, if we could do an add-on. Apparently, he has 2 other cases that are holding him in that are not on today's calendar. So if you could just please oblige us, and would like to resolve all 3 cases together if possible. Pretty please.
Y'all are so scared of Miss Lewis.
Yeah. Like
I don't know what you've done to them, Miss Lewis, but
Yeah, like Mr. Walker said, if possible, so the case that's on the calendar today, he has a signature bond on, and then the two other misdemeanors that are not on here, he has no bond. So,
Okay, so when do you want to reset them to, Mr. Finley?
I mean, if possible, Thursday, but once again, whatever.
Okay, so what, when I reset things, if we can reset them for one of my calendars instead of
Okay,
another judge's calendar, so can we hold off until next Tuesday?
we can do that.
Okay, so we'll reset it, set it till next Tuesday so that I can, hear it, okay?
Okay.
Can I make sure I get all of the case numbers that you guys gonna present? on
PD
that?
Finley, can you assist me in that,
Yes,
please? Thank you.
I will, no problem. Thank you.
All right. Who do we have next?
Next, we have Mr. Bass, BASS, and he's position number 4.
And this is a negotiated plea, Judge.
Good morning, Mr. Bass. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, Your Honor.
Thank you. Mr. Bass, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Okay, you can put your hand down. Thank you. Mr. Walker? You're on mute, Mr. Walker.
The state's recommendation is 12 months to serve 60 days, credit for time served of 23 days, balance suspended, no further contact with the victim, whose name I will provide shortly.
And Judge, that was our understanding of the offer, which we do agree and do stipulate the factual basis, venue and ID.
1 second. I'm sorry, y'all. I typically would have the names, but these aren't my cases. Victim's name is Sierra Hunter. And since it's the same victim in 2 counts, we'll just say count 2 will merge into count 1. Or, yeah, if possible.
So he count 2. So he's only pleading guilty to simple battery, family violence. Is that correct?
Yeah, we'll let the simple assault merge if the court will allow it.
Okay, yeah, that's fine with me. And as far as, so is the balance suspended?
That's yes, Your Honor.
Okay, so he's only gonna do extra jail time, and once he does the extra jail time, he's gonna be done.
Yes, Your Honor. And I think the reason for that is because it's a 2019 case.
Okay. Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which Mr. Bass and I do agree.
Okay. Mr. Bass, it's my understanding that in case 20 CR 000191F, you wish to plead guilty to simple battery, family violence. Is that correct?
Yes, sir, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Bass. Good luck to you, sir.
All right, thank you. Next, we have position 25, Mr. Kildraw.
Your Honor, in Mr. Kilgore's case, he had been listed as outsourced, and it turns out he's there now. Given what the offer is, there would be no harm to him to reset this for 1 week so I could interview him in person ahead of time, which is our office policy. And he has said, let's do that.
Okay, you're fine, Mr. McLean. We'll reset this till next Tuesday.
Thank you.
All right, we'll see you next Tuesday, Mr. Kildraw.
Sir.
Position 32, Muhammad, Department Counsel.
What number?
This is position 32. This is Mr. Rails. Mr. Rails' client, what are we doing with Mr. Muhammad this morning?
Good morning, Judge. I think my lighting is kind of poor, but maybe you can see me through the smoke here.
I can see you. You're fine.
Oh, great. My right
Okay.
side, Judge.
Okay.
So what we're doing is this. The solicitor and I have spoken for a brief minute. He's indicated to me that it's possible that this situation could possibly be returned to the division judge instead of this court hearing it today and now. However, the situation is actually desperate, and I don't know if that would be accurate or not. All we're trying to do today is there is currently a bond on the case. It is a cash bond. In turn, but that bond the cash can be money that she just doesn't have. She can definitely put up a surety bond. I have witnesses here today that would be on Zoom before the court to explain the situation and explain to the court why it is that a surety bond ought to be granted. I'd like the court to hear it, and that's the purpose of the situation. The solicitor has basically said that he believes that the situation is such that she should continue to do another with good time and all. I don't follow it to the exact minute. But that she might have to do what would amount to another 10 or 15 days. That's not acceptable. We can't do that. And I'd like the court to hear why we ought to make this into a surety bond.
And Your Honor, I will say, I did talk to counsel. This is ASG's Segura's case, but briefly, the defendant has FTA 3 times. The first bench warrant was set aside. She went ahead and FTA'd another 2 times and now has a cash bond that was set by Judge Edie. So counsel asked what I could send to a surety bond, and I was like, absolutely not. She's FTA'd 3 times. We already set aside 1 bench warrant. She has a cash bond for a reason. We typically send it back to the division judge, and I was going to ask the court to treat this case as we would any other case. I'm sure counsel is going to say there's extenuating circumstances, but at the point that you refused to show up to court on 3 different occasions after 1 bench warrant has already been set aside, the state is standing firm on its position. But I will.
Okay, I mean, Mr. Rell, knowing that my normal policy is I will hear a modification of a in certain cases, and in certain cases, if they've been issued by the division judge, I have the case returned to the division judge so that they can hear it, given that they are the ones that have issued that bond. So I don't know why this would be any different than what I normally do. If you want to, I'm happy to hear you out as far as that goes, but with
right. Well, I would like the court to make an exception to that general rule. I have 2 people that may convince the court otherwise, maybe not, and they can testify.
And does this go to the issue as to why Ms. Muhammad missed court on 3 occasions?
No, it actually does not.
Okay, so I'm not inclined, if it doesn't go to the issue of why she missed court on 3 occasions, then then I'm more inclined to let you argue that in front of Judge Edie, who was the one who issued the bond for the case.
Okay, I understand.
All right, so and hopefully or possibly you can get relief that way.
I appreciate that. By the way, on a very quick side note, I just decided very quickly to look up under LinkedIn who my judge was, and it appeared that one of the people that said nice things to the court was Jim Vidita. Jim and I actually were roommates together when I was at William and Mary. I don't know if the court knows him or doesn't know him, but sounds like he might. And I just thought that was interesting to note.
Okay.
I'm confused, but okay.
All right, that does not affect my decision, and I
No,
wish
of course not.
wish you luck, counsel. All right, so we'll
Sure.
return this to division judge, and you can argue for your bond modification at that time.
All right.
All right.
May I have a breakout for a moment with the defendant? Can that be done?
Yes, can we put counsel and I guess it's medical into a breakout room? And while we're doing that, can we move on to the next case?
Yes, Your Honor. We're back at the South Annex, position number 7, Ms. Bridges.
And this is going to be a non-negotiated plea, is that right?
That's
Yeah,
correct, Judge.
it is, and I think it's more so, and I'll let PD Finley speak to that. I think it's more so due to the issue of contact, but let me pull up my notes here, Your Honor.
And yeah, Mr. Walker is exactly right. It's just in regards to the no further contact. And I did speak to her boyfriend. He did confirm. I'm not sure if he's on the Zoom. He said he was going to join, but I know he was at work. I don't see. I can try to give him a quick call.
Okay, let me just start with the basics here, and we'll get back with that. Good morning, Ms. Bridges. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Nothing but the truth.
Okay, very good. You can put your hand down. Thank you, Ms. Bridges. Are you ready to proceed, Mr. Walker?
Yes, Your Honor. The state's recommendation is going to be 12 months to serve, 58 days, credit for time served, 29 days, balance probated with the conditions of an 8-week anger management and no further contact with the other party. Actually was a dual arrest. His name is Sebastian Farley. And I know that the counsel is asking for contact with the other party, Mr. Farley, but the reason why the state is adamant about a no contact order is because these two individuals do have a history of violence. Going back to 14 CR 014443, Mr. Farley was actually convicted, I believe, of battery family violence, and Ms. Bridges was the victim in that case. So with that being said, this is not our first rodeo. They have a history of domestic violence, and for that reason, the state is most comfortable with no further contact.
Mr. Finley?
Yes, Judge. So I did speak with Mr. Sebastian last night. He said he's going to try his best to be on the Zoom. I'm unable to get a hold of him now. He did say he was going to be at work, but he said that he unequivocally did want contact, Judge. I do recognize their previous history. They have been together for going on 10 years now. Now, despite being together for 10 years, they actually don't live together. But they are in a relationship, Judge, and have been for 10 years now. So I definitely understand it would be better if he was on. But like I said, I did speak with him last night, Judge.
Okay, so does Ms. Bridges have a history of violence?
1 second, Your Honor.
Ms. Jackson?
I see 2016 battery family violence that was null process as far as convictions. I see a 2007 disorderly conduct and a 2011 probation violation. So it wasn't so much that she had a history of violence, but as counsel stated, they've been together for 10 years, and between the two of them, they've had 3 domestic violence cases. And the other party in this matter, he was convicted of domestic violence, and she was the victim in that case. So it just seems like it's been a tumultuous 10 years.
What year was that, Mr. Walker, that he was?
That is a 14 CR number, so I'm assuming 2013, 2014. And his case was actually upgraded to the DA's office because this was the dual arrest.
Oh, okay. So is there on his bond, do you know?
It's no further violent. It was no further violent contact, but like I said, at this point, we have 3 DV cases in a period of 10 years. So that's the reason or the basis for the state's no contact request.
Okay, all right, well, I'm gonna let them work it out, so, and if there is, any additional, you know, it will be addressed, at the appropriate time. All right, anything further, Mr. Finley?
Nothing further, Judge.
All right, Ms. Bridges, it's my understanding that in case 19 CR 002803Y, you wish to plead guilty to simple assault family violence, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yeah.
Has anyone forced or coerced you to plead guilty?
No.
All right, I'll accept the plea as negotiated, except for the fact that there will be no further violent contact with Mr. Farley. I'm going to waive the probation fees for you, Ms. Bridges, while you're on probation to help you get and stay on your feet. But I'm going to require that you be on probation for the entire 12 months. Okay?
12 months.
Yes, ma'am.
Okay.
All right. Good luck to you, ma'am. Who do we have next?
Next, we have position 19. I'm sorry. Position 23, Miss Howard.
And what's the announcement on Miss Howard?
Judge, I would need to speak with Ms. Howard.
Okay.
I apologize.
That's fine. So if we could,
You can call.
okay, if you can call, do we have anyone else that's not Mr. Finley's case?
So I actually have, other than if there's ones that are, or actually Miss McLeod, I believe, has position 37. And I think Miss Taylor add on as well. Miss McLeod can speak to that better.
Okay, so if we can have Mr. Finley call to speak with his client and if we can get one of Miss McLeod's cases.
It's Zachary Daniel, Your Honor. That's the person.
Position 37.
Yes, Your Honor.
And this is going to be a negotiated plea, is that correct?
That is correct, Your Honor.
Okay. Good morning, Ms. Zachary. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Good morning. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court, the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Ms. Zachary. Ms. Johnson?
Yes, Your Honor. This is a negotiated plea. The state is offering 12 months to serve 30 days, credit for time served 15 days, a balance probated, 6 weeks anger management, no further contact with Emmanuel Teague. That name is spelled E-M-A-N-U-E-L.
Hey, Ms. Howard. Hey, how you doing? Hey, this is
Last
Defender.
Mr. Finley, we can hear you. Thank you. Go ahead. I'm sorry, Ms. Johnson. Go ahead.
All right. His name is Emmanuel Teague. First name E-M-A-N-U-E-L. Last name Teague, T-E-A-G-U-E. A stay away from the incident location. That's the 5 Points MARTA station. She does currently have a suspension that does not expire until October 8th, 2022, but we will still ask that she stay away from 30 Alabama Street Southwest. That's the 5 Points MARTA station. We'd also ask that she stay out of MARTA in general, Your Honor. And we also ask for no alcohol, drugs, or weapons.
Okay, Ms. McLeod?
Yes, Your Honor. That is our understanding of the plea as stated.
And, okay.
Except for the stay away from MARTA. I did not know that that was a part of the plea.
Okay, I'm gonna have her stay away from MARTA doing any suspensions. So if there's an active MARTA suspension, then she's gonna have to stay away, okay?
Yes, Your Honor, we understand that.
Okay. Anything further?
No, Your Honor, that's it.
Nothing further from the state, Your Honor.
Okay. Ms. Zachary, it's my understanding that in case 22 CR 005474D, you wish to plead guilty to simple battery and criminal trespass, is that correct?
Yes, I have a question.
Okay, Ms. McLeod,
It's okay for her to ask, Your Honor.
okay.
I
What's
just
your
want to
question?
know, can I get my property back from Marta? Because I took, I,
Okay,
She just has a general question about getting back her property, which was taken at the time of her arrest.
okay, so does she need a one-time escort to get the property back? Is that what you're asking for?
Yes, Your Honor, from Marta.
Okay, all right. I will give you a one-time escort with police enforcement to go to Marta to get any.
thank you.
Can you hear me?
Yes, she said thank you, Your Honor.
Okay, all right. And can you unmute South Annex? Okay, so it's my understanding that you wish to plead guilty to simple battery and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. I'm going to waive the fees for you while you're on probation to help you get and stay on your feet. I'm going to require that you be on probation for the entire time, and you can have a one-time police escort to go to Marta to retrieve any belongings that they may have of yours. Okay?
And time is 6 weeks.
Say it again.
Probation for 6 weeks until I complete anger management.
No, you'll be on probation for the entire time, but I'm going to waive the fees for you while you're on probation.
You will be on probation, but there will be no fees.
How long is the probation period?
It's 12 months.
I thought they said 6 weeks until I complete anger management.
Ms. McLeod, no one.
Suspended. My understanding was after the anger management, it would be suspended, Your Honor.
Okay, those are things that you're going to have to inform me of. Ms. Johnson, is that what you're?
It wasn't in my original offer, Your Honor.
Okay.
It was balance probated.
Is there a history in the matter?
She has 3 cycles. Originally, she's a theft by receiving stolen property, possession of marijuana misdemeanor, excuse me, possession of controlled substance 4, possession of controlled substance 1 in 2022, Clayton County, that she's on probation for right now. But this was her 3rd arrest.
They're charging me with.
Hold on, Ms. Zachary. I'm gonna let it go to a non-reporting status after she completes the terms. Okay.
Yes, Your Honor.
So you'll still be on probation, Ms. Zachary, but once you complete the terms of the probation, it'll go to a non-reporting status, so you won't have to go in. Okay.
Okay.
All right. Good luck to you, ma'am.
Thank you.
Thank you, Your Honor.
Yes, we have position number 5, Mr. Bell.
And
That's a negotiated plea, Your Honor. It had been put down as to be announced because he needed to check with family on a financial matter really quickly, and we did. So that is a negotiated plea at this time.
Okay. Good morning, Mr. Bell. I'm Judge Eric Morrow. This is the State Court Expedited Act. This is the State Court All-Purpose Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you hear me, Mr.?
Yes, I do.
Okay. You're going to have to speak up a bit for me, sir. Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Walker?
Yes, Your Honor. The state's recommendation to the one count of simple battery family violence is 12 months to serve, 28 days, credit for time served, 14 days, balance probated, FVIP, no further contact with the victim, Joanne Hogan, and a stay away from the incident address. If you just give me 1 second, I can give that to you very quickly, hopefully. Oh. Okay, we can come back to the part. I'll give you the address before the end of the plea, though.
Okay. Mr. McLean?
Your Honor, he does understand that FVIP is very involved, and he asked the court to accept his plea.
Okay, and that incident location is 6354 Shannon Parkway, Union City, Georgia.
All right. Mr. Bell, it's my understanding that in case 19 CR 001927J, you wish to plead guilty to simple battery, family violence, and simple battery, is that correct?
Yes, yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
Your Honor, I'm sorry to interrupt. There was something I had sent in the chat to Mr. Walker. One of the cases was going to merge, and my chat was about which one merging. What do you think, Mr. Walker?
Okay, give me 1 second.
It was not crossed on the second charge.
It'll be easier if they allow count 2 to merge. That's fine.
So,
the simple battery will merge into the simple battery family violence.
Okay.
And what the chat was asking was because of a certain factor, could the state live with the simple battery family violence merging into the simple battery? They were never married.
I don't think that's possible because family violence is an additional element, so it would have to go the other way, right?
Well, I should put it as it is in the offer. The null pros of one for the plea of the other. The accusation says they were married and spouses, and they were never married. Can you go with that? You might could go on another element.
That was the offer that was extended. If we need to have an offline conversation, we can, but I don't like to renegotiate in the middle of a plea because this is all new information to me. So I mean, if he's not comfortable to the family violence, maybe we could take this at the end of the calendar, but that's not what was extended as an offer, and this is
right. That's why I put it in the chat. So
and I'm sure
I'll put it at the end of the calendar and talk on the phone with Mr. Walker for a minute.
I'm sorry, Judge.
Okay, you're fine. So, Mr. Bell, we'll be back with you, sir.
All right.
Okay.
Thank you.
And number 34 is gonna be a medical reset.
34, okay.
Judge Morrow.
Yes.
My business before the court is concluded. May I be excused?
Yes, Ms. McLeod, you have a good day.
Ms.
Thank
McLeod, can you please make sure you send me your plea paperwork?
I will.
Thank you, ma'am.
You're welcome.
Okay, who can we take next?
Position number 23, Ms. Howard.
And Judge, this is just going to be an arraignment.
Okay. Good morning, Ms. Howard. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you, ma'am. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Ms. Howard, you've been charged in case 22 CR 005374C with criminal trespass and disorderly conduct. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Mr. Finley?
Yes, sir.
Judge.
How do you plead to these charges, Ms. Howard? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, ma'am.
Next is position 36, Ms. Wilder.
Negotiated plea, is that correct?
Judge, this is gonna be actually non-negotiated with the class at issue. And just want to confirm with Mr. Walker, I didn't see if it said balance probated. It wasn't there, but I'm assuming.
I'm just heard the tail end, but if there's a class, I would assume that it's supposed to be probated. I'm sorry if that was omitted.
Yeah, no worries. So yes, Judge, it would just be non-negotiated with the class and balance probated at issue.
Good morning, Ms. Wilder. I'm Judge Eric Worrell. Good morning. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can put your hand down. Ms. Johnson?
Thank you, Your Honor. Would you like me to proceed with the facts or the offer first, Your Honor? Do you stipulate to the facts, Mr. Finley?
I do.
Okay. So the state's offer was 12 months to serve 30 days, credit for time served 15 days with a balance probated, a theft prevention class, and a stay away from 2095 Campbellton Road Southwest.
What were the facts, Ms. Johnson?
I believe, Mr. Finley, you want me to put them on the record? Excuse me.
Yes, you're fine. I just want to make given that he has an issue with the class, I want to know what transpired.
Of course. Police responded to the location. Mr. Jones was seen holding a bat aggressively and walking towards the defendant. Mr. Jones was asked to drop the bat and lay to the ground. He was placed in handcuffs in the back of the patrol vehicle. Mr. Vita Jones advised officers he was sleeping in his chair in the middle of the divider of the intersection of Deloy and Campbellton when the defendant snatched his phone and walked away. The defendant tossed the phone into a bush. So basically, Your Honor, the defendant did steal Mr. Vita Jones's phone, and Vita is VIDA.
Okay. Mr. Finley?
Yes, Judge. So as previously stated, I am the balance probated as an issue. I'm asking for her not to have to do the theft prevention class and for the balance to be suspended. Miss Wilder is homeless. She has no phone, no address, no money, and no one that is able and willing to help her get on her feet. So in my eyes, Judge, probation is a recipe for failure, and it's a recipe for her to return to the exact seat she's sitting in right now. So I am asking for the balance to be suspended, Judge, and for the jail time she's already served to suffice. I just don't want to put her in a situation where she's bound to fail.
Is there any history of theft?
Yeah, and I have 18 previous arrests. She doesn't have convictions for arrest, but she does have several arrests for theft by shoplifting. I see an arrest for in 2008, a theft by shoplifting in 2020 in Fulton. Those are only theft charges I see.
Okay.
But she does have she has 5 previous convictions.
All right. I think 15 days in jail is enough time, so the balance will be suspended, Mr. Finley. Ms. Wilder, it's my understanding that in case 22 CR 005371J, you wish to plead guilty to theft by taking, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty? I'll accept your guilty plea, Ms. Wilder. It's going to be 12 months to serve 30 days, credit for time served 15 days, balance suspended. Good luck to you, ma'am.
Good, thank you.
All right, Your Honor, I don't know if the jail can go back to, well, the stay is ready for Jonathan Bell, whenever the court is.
May we be excused, Your Honor, from the South Annex?
Yes, have a good day.
Bye-bye.
You right here.
Okay, so this is Mr. Bell, position number 5.
Yes, it's Mr. McLean's case. I'm not sure. I think he might have hopped off right quick.
I had, the issue I put into the chat at 9:30.
I will oblige the request. I understand the accusation says that they were married. Just for the purposes of the record, that information came from the defendant. He advised officers they were married, but I do realize this is a 2017 case and it's been a long day. So I will give you what you're asking for. So he could plead to the simple battery, and we will now process simple battery family violence. But unfortunately, it can't merge. So it'll have to be a no.
Right. He totally appreciates that. He's very happy. Thank you.
You're welcome.
Okay, and since we're getting back to this, Mr. Walker, would you please just let the court know what the
Yes. 12 months to serve, 28 days, credit for time served, 14 days, balance probated with the conditions of FVIP, stay away from the victim whose name is Joanne Hogan. And let me get that address for you one more time. I know it's a Union City address. Address is 6354 Shannon Parkway, Union City, Georgia.
Okay.
And again, that's to the one count of just simple battery.
Okay, thank you, Mr. Walker. Mr. McLean?
And he asked the court to accept his plea, Your Honor.
Mr. Bell, it's my understanding that you wish to plead guilty to simple battery. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anybody forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated. I'm going to waive the probation fees for you, Mr. Bell, while you're on probation to help you get and stay on your feet, okay?
Okay.
All right, good luck to you, sir.
So I'll be released today?
You'll be released as soon, if you don't have anything holding you, you'll be released as soon as the jail can process you out, okay?
Okay, thank you.
Okay, you're welcome. Have a good day, sir.
All right,
Position number 10, Crane.
And Mr. Crane is very hard of hearing. I don't know, is there a speaker by chance that you could like hold close to him?
No, I don't have a speaker.
Okay.
Mr. Crane, can you hear me?
Can you hear the judge, Mr. Crane?
Can you hear me, Mr. Can he put his ear up to the?
Can you put your ear up to the computer? Put your ear up to the computer.
Can you hear me, Mr. Crane? Can you hear me?
Can you hear the judge, Mr. Crane?
Mr. Crane, if you can hear the judge, if you could respond with a yes or no, sir.
Can you hear the judge?
Okay, can he hear you?
Can you hear me, Mr. Crane? Can you hear me? I'm Officer Blunt. Can you? He cannot hear me totally either. No.
Yeah.
If he, if he can't even.
I had to kind of, when I spoke with him yesterday, I kind of had to pretty much scream into the between the glass, and he could. Yeah, but it was a difficult conversation.
Give me one second. Let me just check my notes here. Let me see what we can do.
So Mr. Crane, Mr. Crane has been reset quite a few times. I've tried to meet with him and I've been unable. So this was the first time I've been able to meet with him. So
and what's the offer?
It's time served.
Is anything holding him?
I have that there's nothing holding it. Let me double check that, Judge.
Is it
Yeah,
is it a
Judge.
straight- It's a straight time served plea?
Yeah,
It
Judge.
is.
It is and it is, he has nothing holding him. I think I have at least, I think 6 times that I've tried to see him. And I was not allowed to see him. So this was the first time I've been able to. So
All right, so you all tell me, do you want to try to do a plea in absentia? I mean, I don't want to keep the man in custody if there's
yeah,
nothing
I mean,
holding him.
right. I mean, like I said, I had to pretty much scream through the door so you could hear me, and he was able to give some verbal cues to where he could understand me. I asked some questions where he'd say no to. He did make somewhat of a no and then somewhat of a yes as well. So,
What would you like me to do, Mr. Finley?
I mean, I would obviously, like him to get out. I'm just kind of, there's been so many failed attempts to meet with him. But obviously I want him to get out. But yeah, I'm kind of at a loss. So,
Do you have the paperwork to do a plea in absentia?
no, I haven't done that before, but I will have to get that.
I can send you a form and you can complete it with.
You wouldn't
them,
mind, Ms. Lewis?
And you can complete it with them and then submit it to the courts, and then we can go from there.
Sorry, Ms. Lewis, could you say it one time?
I said I could send you a plea and essential form, and then you can complete it and then send it back to you for the courts.
Okay.
All right, is that what you want to do, Mr. Finley?
Well,
Mr. Walker?
Mr. McLean?
I'll just not process the case. I do have some concerns because there were some in the report, there were some MH concerns that were listed. So I don't know if Mr. Crane has anywhere to go. I don't know if your social worker wants to talk to him. I just don't want to release him to the streets.
I understand. And I'm gonna reach out to Nakasha and see if she can.
Can she talk to him today? Do you know?
Should be able to. That's what I'm hoping. I'm gonna reach out to her right now though.
So if he has a social worker visit, Mr. Walker, it's my understanding that you would consider not processing the case.
Yeah, and that's just because I read the report and there's some MH and he's clearly homeless and he needs somewhere to go.
Okay.
Yeah.
I think that's evident.
I'm in agreement.
You two get together after court and I'll sign a null process if that comes my way.
Okay.
Okay.
That sounds like a plan.
Okay.
Reach out to a social worker. Understood.
All right, thank you. We'll be with him. Do we have anybody else in medical today?
No, we don't.
All right, thank you.
Do we need to resend him just for the paperwork to come through, or just hold on to the file until I get the paperwork? What we doing?
We're good. Go ahead, Judge.
Hopefully you all get this done today and you can get Ms. Lewis the paperwork. And if you can't get it done today, contact Ms. Lewis so that we can put him on another calendar.
Well, for abundant of cautions, I would just put him on for Tuesday.
Okay, that's fine.
Yeah.
Okay.
Okay. Who else do we have? we have anyone else in courtroom? I haven't, some more people on the calendar that we haven't addressed yet. I don't know where they are.
Your Honor, I could speak to Eric Smith's situation.
What position is that?
Let's see, he is
Eric Smith,
34.
That was a
No,
medical
30.
that was a medical reset. Eric Smith?
He was moved, when I went to see him at the jail, he was moved from 5 South and 5 North, and then ended up somehow at Marietta Annex. So if we could reset that 1 week, that would work.
Well, the
Okay.
jail
Well,
just
the
came
jail-
out and did a medical reset.
Yeah, the jail has already informed us that he was going to be a medical reset.
Okay.
Okay.
I don't know if that had anything to do with him moving around, but that's fine.
Well, we can set it out 2 weeks if you need to.
Okay. What about, let me just, position number 3, Mr. Babb? Whose case is that?
That was a release, Judge. Number 3.
Yeah, that was a release, right?
Okay. So does that take care of everyone on the 9 o'clock calendar? Is there anybody that we missed?
Did we address 21 Holland?
No.
It doesn't appear so.
No.
Was there somebody on Zoom for Mr. Holland today?
Who's representing Mr. Holland?
I do.
Do we still have someone from the jail on?
I do not see. Well, they're muted courtroom 2 is still on there.
Mr. Jordan, are you with us?
No, it's Miss Champion today.
Oh, Ms. Champion, good afternoon. Good morning.
Good morning, Judge.
Can we inquire about position 21 with the jail, Mr. Holland?
Yes, Judge, I'll call out to courtroom 2.
Okay. And I had a probation revocation calendar, but I don't see.
Probation is on the line. Miss Harris is down there. Miss Trenda Harris, probation, she's on the line.
Okay, so we still had 2 probation. Did the jail get the probation revocation calendars?
And I did.
Only one is in jail, and there's a situation with the first one I think Miss Harris will talk about.
Good morning, Your Honor.
Good morning, Ms.
For Mr. Christopher Garrison, I informed Mr. Finley that he noticed Mr. Garrison to appear in person, but I did not realize Zoom was today. And I wanted to see if I could actually reset his case to have it sent to Judge Porter.
Okay, so that's Mr. Garrison?
Yes, Your Honor.
Okay, so that's fine with me. And what about Mr. Turner?
Mr. Turner, actually, he never should have been on the calendar. He was on probation from years ago. We already sent a whole release on him for that case.
Okay, all right, so that takes care of the probation revocation calendar.
Your Honor.
Okay, thank you.
Your Honor,
Miss Middleton informed me to let you know that she is leaving and she wants to tell you goodbye.
Oh, okay. I hate to hear that. Tell her I wish her all the best.
You want to see Miss Middleton real quick?
Yes.
Okay, give me 1 second.
Okay. And let's see, while we're waiting on that.
Your Honor, Ms. McLeod has said that someone on the behalf of Ronard Bird has contacted them and he wants to change his mind to a plea. I have no objection to that if he wants to. We did discuss the case and all the possibilities. So if he wants to go with a plea, certainly that was within the ambit of our discussions, although it was not his wish yesterday. It can be his wish today.
Yes, Your Honor, I was called by someone on his behalf from the jail and asked to relay that message to Mr. McLean.
Okay, thank you.
He said the camera was frozen, so he wasn't able to tell him that or something like that.
Okay, so I guess if we can get him back. I'm happy to take the plea if that's what you all decide to do. Mr. Middleton, we hate to see you go. It's been a pleasure working with you. I wish you all the best in your future endeavors. You're gonna be missed in this court.
I'm gonna miss you too. Thank you, Judge.
Where you headed to?
I'm headed to an insurance company, so I'll be doing claims for an insurance company now.
All right, very good, very good. I hope you enjoyed that.
I may come back and visit sometime.
Oh, please do. We're happy to have you.
Oh, no problem. I'll see you guys soon.
All right, good luck.
I do got a question, Judge. Well, I guess it's to the PDs. Y'all indicate people who outsource. Have y'all confirmed that with the judges? With the jail regarding the outsource on the cases that y'all indicated? So
Yes.
you need to reset them like a 2 weeks out for to get the information coming up, or how y'all
Yes.
want the days reset?
Yeah, so that's how the jail is who told us they were outsourced. We always double check, even if we see it online or on the Odyssey, we wait to hear the jail say that. So each of those have been confirmed by the jail. So yeah, if we could, I guess, have those reset to have time to go over there and meet with them.
Okay, well, what about the 16th? Is that gonna be enough time for to get the information and counter out to the individual resources?
That works. Yes,
Okay.
that works. Let's do it.
Thank you.
Right now, number 8 would fall into that, Larry Brown.
Okay.
Do we have anyone from the bench warrant calendar?
And I tried to I was unable and have been unable to get a hold of the gentleman that's on the bench calendar.
Okay, so in that case, the bench warrant will not be withdrawn. Let me just sound for him. Deterius Postel.
Yes, I'm here.
All right, Mr. Finley, do you need to speak with Mr. Postel?
Yes, I do.
Okay, can you go? We'll put you all into a breakout room then.
Okay, thank you.
And Ms. Lewis, can we just go over the calendar? If that's all right with Mr. Finley, can you get the information from Mr. McLean, or would you like for us to hold? For you?
That works. I can go ahead and talk to Mr. Postel.
Okay. All
Give me 1 second. I'm still combing
right.
over. Quick.
All right. So just let me know when you're ready.
Okay.
Are we finished?
We are holding on. We need to get a couple more people, Officer Middleton, and I don't know if you can assist us.
Are the females?
I don't think so.
Okay.
Ms. Champion?
Yes, Judge, I just spoke with Sergeant Johnson. She told me she's gonna call me right back. She's gonna check on, position 21 and, Mr. Byrd to see what's going on.
Okay, thank you. And would you go ahead and put, Detarius and Mr. Finley into a breakout room for us, please?
Okay.
Thank you.
Okay, Judge, I'm ready. I don't know, Mr. You wait for Mr. Finley to come back on the line or just go for.
No, he said to proceed, so let's,
Okay.
just go.
Okay, I'm gonna start with the add-on calendar. Position number 1, add-on, defendant was arraigned, case is reset for the jury for the notice. Position number 2 was a plea add-on. Position number 3 add-on is gonna be reset for the SAP for 9/6. That's gonna be an add-on. Position number 4 was a plea. That was the add-on calendar that I just talked about. Now I'm going to the regular calendar. Position number 1, defendant was arraigned. The case is reset for jail jury for the notice. Position number 2 was a plea. Position number 3 is going to reset for the notice. Defendant was released. Position number 4 was a plea, extra time. Position number 5 was a plea. Position number 6 was a plea. Position number 7 was a non-negotiated plea. Position number 8 is going to be reset to the SAP for September the 13th, to give enough time since it's an outsourced agent involved. Position number 9, defendant was arraigned. The case is reset for trial, jail, jury for the notice. Oh, no, we're holding back on him. And he's supposed to come back for a opportunity for a plea. Wasn't that for Mr. 9, Mr. Bryant?
Yeah, Mr. Byrd, yes.
Bird, okay, so we still holding on him, so we don't know. Okay. All right, position number 10 is reset for SAP for September the 6th. Position number or a plea in absentia. Whatever comes first. Position number 11 was a plea. Position number 12 is reset for September 13, SAP. Position number 13, it was defendant was arraigned. Case is reset for trial for the notice. A bond modification was made, reduced to $1,500 surety. Position number 14, defendant was released. Case is reset for the notice. Position 15, the defendant, they waive arraignment. Case is going to reset for jail jury for the notice. Position number 16, it's going to be reset to September the 16th. SAP. Position number 17 is going to be reset to SAP September the 6th. Position number 18 is defendant was arraigned. The case is reset for trial for the notice. Position number 19 is reset for SAP September the 6th. Position 20 was a plea. Position 21, we're still holding. Position number 22, defendant waive arraignment. Case is reset for trial for the notice. Position 23, defendant was arraigned. Case is reset for trial for the notice. Position 24, defendant was released. Case is reset for the notice. Position 25, the case is going to reset for the SAP for September the 16th. Position 26 is reset for SAP September the 6th, along with this other case. Position number 27, defendant waive arraignment. Also the same announcement for 28. Position number 29 was a plea. Position 30 was a plea. Position 31 was a plea. Position 32 is reset for jail jury for the notice. Position number 33 was a plea. Position number 34 is a medical reset, going to be set to September the 13th. SAP. Position 35 is reset for the notice. Defendant made bond. They just haven't released her yet. Position number 36 was a non-negotiated plea. Position 37 was a plea. And I guess we're waiting on the announcement for the DV case and the two other defendants that we're holding on.
Okay, thank you, Ms. Lewis. Can we go to Mr. Postel now? Mr. Finley,
Yes, Judge.
Mr. Walker, is this, yes.
I'm here, Your Honor.
All right, so what's going on with Mr. Postel?
Would you like to go first, Zach, or?
What's that?
I said, Zach, would you like to go first, or?
Sure, I can do that. So yes, Judge Morrow, I did just speak with Mr. Postel. He is aware that he did miss court. He actually was made aware that he missed court from his bonding company. And as soon as he heard from his bonding company, he immediately went down in person and made sure to reschedule that court date. But as soon as he found out, he was proactive and did go down to the courthouse, Judge. He adamantly states he did not get any paperwork. He's not trying to run. And if he did know and did have notice of court, he unequivocally would have been at court. He lives with his grandma. He's not sure if something happened with the paperwork or so on. But once again, adamantly states, Judge, if he knew there was court, he would have been there. He has previously worked at Buckhead Meats as a forklift driver. Once again, he does live with his grandma, so he does have a good housing situation. And he does have 3 young kids, ages 3, 4, and 5 that he does help support. And so, Judge, I just am asking for the bench warrant to be set aside. I do have this address. The address is on file is correct. But he once again states that if he gets notice, he unequivocally will be there. He has had court in a neighboring county and has been at court there when he's gotten notice. So I'm asking for it to be set aside, Judge.
Okay, 1 second, Your Honor. I'm just trying to get my dates and the procedural posture of both these cases correct, because I do not want to misquote anything. As you're aware, Mr. Postel is in front of the court today because he FTA'd on both of his cases June 11th of this year, I believe. Both of those cases were in front of Judge Betson. The state is adamantly opposed to the bench warrants being set aside for a couple of reasons. A, we're here for 2 cases with the same exact victim. Going back to the first incident day of August 6th of 2020, that's position 1. The defendant was not on the scene at the time that law enforcement was dispatched, but warrants were taken out for his arrest. Mr. Postel was not picked up until November 1st of that year. And the only reason why he was picked up on those warrants is because he was picked up at the same time for 20 DA 09161, which is a felony weapons charge. He eventually made bond on position 1 and that felony weapons charge, and he has since reoffended with the same victim, which gives us position 2. He then FTA'd. Currently on position 1, I spoke with the case manager. According to her, it's a $6,000 surety bond on the bench warrant total, and on position 2, it's a $5,000 surety bond on the bench warrant total. Based upon him having 2 open cases, him picking up a felony weapons case, and that's the only reason why he was picked up on the first case, the state has a lot of concern. With that being said, I think the most appropriate thing would be for Mr. Postel to be remanded into custody and post the bond as assigned by Judge Besson, according to the bench warrant. We have 2 cases, same victim. He's out committing felonies. I get that he's presumed innocent until proven guilty, but there's a lot of concern that the state has for the safety of the victim, and he did miss both of his court dates. So that's the state's position. I ask that the state or the court not set aside the bench warrant.
I didn't miss.
Mr. Postel, you have a right to remain silent, sir. I suggest that at this point you let Mr. Finley do the speaking for you. Mr. Walker, this June 11th date that he missed, was he called in on both cases at the same time?
He was.
And is this the first time that he's missed a court date?
No, I wasn't.
Mr. Postel, let me speak for you, please, sir.
Let me confirm.
Let me just say, Mr. Postel, I'm about to make a decision as to whether you have to be remanded to custody. So you need to be respectful as far as, as far as that goes. And we've already advised you once to let Mr. Finley do the speaking for you. So it's a serious matter, and I'm trying to get some information regarding it. So you're not helping yourself. It's what I'm telling you. Okay.
I apologize.
Okay.
So Odyssey is not clear, and that's why I had to call Ms. Hardy, the case manager. She just told me that the last FTA or the FTA that she saw was from 7-11, and that was on both cases. I saw that he has previous court dates prior to that, but that's not to say he didn't FTA on those cases, because even on the 7-11 day, it's not listed as a bench warrant. I had to call Chambers to get that information. So I can't say for certain if he's bench warranted other than the 7-11 date. That was just the date that was provided to me. But nonetheless, we have the first case. He makes bond, he reoffends, gets the second case, picks up a felony weapons case, and then FTAs. For obvious reasons, the state has a lot of concern for the safety of the victim. I didn't pull the bond order, but presumably there was a no contact order. Presumably, it probably was a no firearms, drugs, or alcohol condition. But here we are with 2 battered family violence cases and a felony weapons case and a FTA. So I just asked that he's remanded to custody and he pays it's not even a cash bond, it's a surety bond. So I feel like Judge Besson was being more than generous by giving him a surety bond on the bench warrant.
And you notice that it's the typically this court allows the defendant to miss one court date. So, and he came in and he, he's here today. It's been one, from what I'm hearing, it's only, he missed that one time. So regardless, go ahead.
You make your decision. You are correct, but I think this case is different from those other instances because the defendant already had one case and reoffended with the same victim, and now we have two cases. So if this was an instance of, oh, the defendant only had one case, he missed a court date. I get that both cases were called the same day, but I'm saying this instance is different because at this point, this person has already reoffended with the victim for a second time. So,
but I'm not here to address the underlying charges, Mr. Walker. I'm only here to talk about this one.
right, I would just say that goes to bond overall. The reoffense goes to the Ayala factor. So, I mean, essentially, this is a bond hearing. And I'm just saying by him making bond on the first case and then going back and reoffending and picking up a second case will go to the Ayala factors of risk of intimidation of the witness and the victim, and just in bond in general, he's violated the first bond order by picking up the second case. So I would say that is what distinguishes this case from those other instances. It's one thing to have one open battery family violence case, and then you FTA, and you come forward and say, oops, my bad, I got my court dates mixed up. Can you set aside my bench warrant? But the state's position is you've already violated your bond by reoffending and picking up the second case in the first place.
Well, apparently somebody from your office must have made that argument for the second incident, and apparently a bond was granted by someone, right?
I mean, it's a misdemeanor, so he is entitled to a bond, and he does have a bond. I just ask that he post the bond to stay rest.
All right. As far as I'm concerned, this is the first time. Mr. Postel, if you miss court again, then there's not going to be set aside. So this court generally gives you one chance to miss a court date, but if you miss a court date again, then your bond's not going to be set aside. So you need to do whatever you need to do to make sure that you're in court when your case is called. So I'm going to set it aside this one time and just admonish you that you need to be in court the next time, okay?
Yes, sir.
And as Mr. Walker's saying, whatever your bond conditions are, and I'm not really sure what they are, but you need to abide by them. So if there's a stay away, or if there's a no further contact, you'll be in a world of trouble if you violate those conditions. You understand me?
Yes, sir.
All right. Good luck to you, sir.
All right. You have a nice day.
You too. Yes, courtroom 2. An announcement.
Good morning, Judge. I'm sorry. Who are we missing for state all purpose?
We are missing position 9. He wanted to take a plea. And can somebody else help me out? Which other position are we missing?
Holland.
21.
Position 21, Mr. Holland.
Okay, we put Mr. Hollis on the screen earlier this morning. 21.
Say it again.
What's the first name, please?
Antonio Holland.
Okay. Stand by for me, Judge, please.
Okay, thank you.
And did I hear we're trying to take a plea on position 9 as well?
It's my understanding, Mr. McLean said that Mr. Byrne wants to take a plea.
Okay, well, let me prepare that.
That's what I heard.
And let me just admonish Mr. Tony Holland there. Mr. Holland, can you hear me?
Oh, that's Tony Holland Sr. That's the dad.
Okay, well, I'm still want to address Tony Holland Sr.
Certainly,
Tony Holland
certainly
Sr.
understood.
Can you unmute yourself so I can speak to you, sir?
Okay.
Yes, good morning, Mr. Holland. This is an official court session. So if you want to participate in any way, I'm going to need for you to put a shirt on, okay?
Oh, okay.
All right. Thank you, sir.
Thank you, Your Honor.
We will be in recess until someone comes back.
Please make sure you're sending over your plea paperwork and your null process to me in a timely manner. I appreciate it. For the ones that sent it over already, thank you.
Will do. Thank you, Ms. Lewis.
Mr. McCain? This is-
Yes,
This is Ms. Lewis. Did you check your email? I think the Solicitor General, Ms. Lee, she sent over you a plea paperwork for the position that you took a plea on. I don't know.
okay, let me see here, let's see.
I guess she filled out everything for you. I think you just need to print it out and sign your part on there in the defendants. She pretty much did your work for you.
Thank you.
And then, Mr. McClain, I know you're busy, but on position 9, Mr. Byrd, are we resolving both matters or just the primary matter on the calendar?
I believe both matters.
Okay, okay.
I think so, yeah.
All right. It's been a day.
Also in the chat, I just got a message from the probation officer, Ms. Thomas. She's asking all the public defenders, please make sure the contact information is sent over to her. Or you can send it to me and I'll forward it to her, but you want to make sure all the contact information for those who place on probation is completed.
Okay. All right. Sounds good. Thank you.
Miss Lewis, what happened to Larry Brown?
Mr. Brown was what, number 8 on the calendar? I think he's been reset to the SAP for 9/13.
Okay, Mr. McClain, did your office speak with him or did Zach speak with him or?
I think that's
He
one
was-
out resource using another facility.
Yeah, he was outsourced.
Do we know where?
I had it down there. Hold on a second, I'll tell you.
I think Mr. Brown is at Cobb.
Cobb County.
Yeah, Cobb County, all right.
All right, thank you for that information.
Number 9, Mr. Byrd.
So, Mr. McClain, I don't know if this changes, but apparently Mr. Brown was in felony court today. He has a private attorney. It's his intention to hire that same private attorney to handle his misdemeanor matter. So I don't know if you're planning to go to Cobb. That's just word of mouth from the private attorney, but if that saves you a trip from going to Cobb, FYI.
Thank you. Yeah, that sounds logical.
So I guess he's in Superior. They just left out of Superior Court today. So that was the announcement I got from the private attorney.
Sure.
Okay.
Okay, so this is Mr. Byrd, and what are we doing with Mr. Byrd?
I think we're doing a plea on 2 cases for Mr. Byrd.
Okay, so I only have one case on the calendar. What's the second case?
I will
21 CR 00 1516 G. It says criminal trespass -FV.
Right. So is Mr. Byrd on this? Okay. The state's ready, Your Honor.
Okay, I just want to make sure that we have down what the offer is before I go any further. Make sure that everybody's on the same page.
For the primary case on the calendar, 19 CR 002001Y, the battery, substantial physical harm, the state's official offer is 12 months to serve, 34 days, credit for time served, 17 days, balance probated, 12 weeks of anger management, no further contact with the victim whose name is, I just wrote it down, Jermaine Smith, and a stay away from 70 HE Home Drive. No drugs, alcohol, or weapons. For the case that is not on the calendar, 21 CR 001516G, the criminal trespass, family violence. The state's recommendation is going to be 12 months to serve, 34 days, credit for time served, 17 days, balance suspended with no further contact with Gorisha Bridges.
Is that your understanding, Mr. McClain?
Yes, Your Honor. Technically speaking, criminal trespass, family violence is not a species of criminal trespass. It is simply that in the Family Violence Act, when a person commits criminal trespass under certain circumstances, there could be other consequences having to do with certain court orders in the future. But it is simply a criminal trespass with a regular standard maximum punishment.
Well, I'm just letting you know that's what he's charged with. And I'm not amending the charge at this point. So if he does, he doesn't have to take the plea, but
we've just always maintained there's nothing that's actually called that, but we understand why it is designated.
Okay, so is that agreeable with Mr. Byrd?
Yes, he's going forward, Your Honor, on both cases.
Okay. Let me just swear you in again, Mr. Byrd. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Byrd, it's my understanding that in case 19 CR 002001Y, you wish to plead guilty to battery, substantial physical harm, and in case 21 CR 001516G, you wish to plead guilty to criminal trespass, family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, they haven't.
I will accept the plea as negotiated. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. But you're going to have to be on probation for the entire time, okay?
Okay. Thank you.
All right. Good luck to you, Mr. Byrd.
Thank you.
Okay, so the only other case that we're holding on is position 21.
He should be here shortly.
Okay,
Yes.
thank you. We will be in recess until Mr. Holland joins. And Mr. McLean, that's just going to be a arraignment and a bond hearing, is that right?
I'm sorry, Your Honor. Let me turn this down. That I think is about Mr. Holland that came in. I'm sorry, Your Honor. I didn't hear you.
Is that just going to be an arraignment and a bond hearing?
On Mr. Holland?
Yes.
Yes, Your Honor.
Okay. And has is this a bench warrant, or it's a 2019 case? So
I think it may have been a bench warrant, Your Honor. In double checking, I'm not sure about the date. It may have been way back when. I just checked with Odyssey to look at the charge, and although it's on the calendar as carrying weapon without a license, it is in the accusation as simply a CCW.
any help for me, Mr. Walker?
I was looking it up to answer the question about the bench warrant. Please give me 1 second. I can pull it up. What position is Mr. Holland?
He's number
21.
Okay, just give me 2 seconds. I'll be glad to pull it up in Odyssey.
Because if he's out, if he's already, you know, if it's a bench warrant, then he's already been arraigned, and
Yeah, he was arraigned.
okay, so we don't need an arraignment. And was it a bench warrant, Ms. Lewis?
No, it was reset for jail jury, and I guess they brought it back again. Yeah, it was a bench warrant. He did miss court, according to here I'm seeing on August 11th of 2022. Bench warrant was issued.
So of course, as always, we would ask to go back to the division judge.
Right. Who issued the bench warrant? Do you have that, Ms. Lewis?
Judge Richardson.
Okay, Mr. McLean, you know my normal practice that if it's a bench warrant, it goes back to the division judge who issued the bench warrant.
I understand then. Okay.
So we don't need Mr. Holland. Is there anybody in courtroom 2? Ms. Champion, are you there?
Yes, sir.
I'm sorry, can you call courtroom, well, could you call the jail and let them know that we don't need Mr. Holland?
Okay.
And
I'll get hold of the public defender that's assigned to odd and even whatnot in that courtroom.
Okay, all right.
And Judge, the reason why he got a bench warrant because his notice was returned for court, so that's why he failed to appear.
Oh, his notice was returned?
Yeah, yes.
And what did Judge Richardson, what was his bond?
I think this, let me double check here. This was a warrant that you issued out back when we were doing Apollo accounting.
Oh, he
So we would ask you to stick to your own rulings, Your Honor.
Well, if my own rule is me.
Yeah, you issue out the bench warrant.
Oh, okay. Well, then I can hear it. So.
Oh,
okay. All righty.
Ms. Champion, I'm sorry. Are you there?
Yes, sir.
Okay. We will need him.
Okay, I didn't get anyone, so I
Okay.
just
All
I
right.
know that.
No harm, no foul. Good. All right. It's been a day. We will be in recess until Mr. Holland joins us.
I guess it's here.
So do we have Mr. Holland in courtroom 2? I guess they're bringing people in.
Judge, it looked like it was a case off of the Orchid counter. It was, I stand correct, was a status conference counter that you issued the bench warrant off of back on July the 27th.
So since we've got a minute, Mr. Walker, Mr. McLean, what was the original bond?
That's what I'm trying to look up now, but just to provide some additional information, I see that this is not his first FTA. He originally FTA in front of Judge Richardson on 2/3/20, and that was for a plea and arraignment. It looks like he was picked up on that bench warrant at some point in time, because I see that he went to SAP in front of you. I'm trying to see what the bond would sit, but whatever that bond would sit at, he made bond, and then he FTA'd on, I guess, the Orca calendar or the Apollo calendar, whatever it was being called at that time. So I'm looking at the jailings now to see the most recent bond amount. So he started with $1,000 signature bond. He FTA'd on 2/3/20. He went back, got picked up on that bench warrant. I believe you gave him a $2,000 surety bond, which he made. And then he was set for the Orca or the Apollo calendar. And then you gave him it looks like another $2,000 surety bond. And one of those cases, it was a return to sender. But my point is, if you go back to the 2320, he had already FTA. So at that point, we had already been through this rodeo once. He knows to update his address. He was picked up on the bench warrant. He made a new one, made a new bond, and then FTA'd again. So I would just ask that you keep the bond that you set at the Orca calendar in place, because at this point he has 2 FTAs on the same case.
And you gave him a signature bond on the first rodeo, the second rodeo.
Yeah. And it started out as a signature bond at that.
Yeah.
So
Yeah, so he had 2 signature bonds.
that was a lot. I'm sorry, but
It's a $2,000 good bond?
Yes.
Okay,
which is more than reasonable at this point.
I agree. Mr. McLean, you have anything you want to add to this?
Your Honor, the dad and Mr. Hahn himself are telling me that he would like to make the bond, but the bonding companies are requiring $380 instead of the $280 or $250 that would normally be the situation. And so he would like to try the case, but he can't afford his bond right now. Now, he has worked at the Atlanta airport, and in the past, in addition to working at the Atlanta airport, he worked in the car rental center there. His current job was as a production and packing person in a freezer warehouse. They have food, and so they pack the food, they produce it and ship it out. And a couple of years before that, he worked for 2 years in construction, and he is sorry that he missed court. I don't have a good explanation for missing court other than just the possible moving of the address.
Well,
we
he's on the
understand the
line.
problem.
I see him there. So, Mr. McLean, he's gonna have to, it's been a couple of times now. I agree with Mr. Walker regarding this. I'm not inclined to do anything with modifying the bond at this point in time. So,
Well, Mr. Hollins, before you guys, position number 21.
okay, thank you. All right, so if he has a problem with his address, Mr. McLean, or whatever, that's his responsibility to make sure that if he moves or whatever the situation might be, that the first thing he should do if he doesn't want to be in jail is to update the court with his new address, especially given that he's been before the court and before me a number of times. So bond will remain where it is.
So Mr. Holland, I'll reach out to your attorney and Judge Richardson courtroom so they know that you're waiting.
What?
Okay. That concludes the 9 o'clock calendar. Anybody have anything further?
No, Your Honor.
Okay, you all have a good day. We'll see you next time.
Thank you.
Ms. Lewis, I'll get those signed as soon as you get them to me, okay?
Okay, I'll get everything together and send it to you all at once.
Okay, thank you. I appreciate it.
Thank you all. Appreciate it.
All right, have a good day.